Employment law. What every salaried employee should know. Exempt employees. To qualify as exempt, the employee must be paid on a salary basis. Employers must compensate non-exempt workers for all hours worked. And then also deductions and salary integrity. Just to dive into it a little bit more, improper pay deductions, such as docking pay for partial day absences, can then jeopardize an employee's exempt status under the salary basis test. And just a little explanation of exempt versus non-exempt. Exempt is where employees who are not entitled to overtime pay, and non-exempt would be employees who are entitled to overtime pay after 40 hours a week. Exempt versus non-exempt. To go a little bit into HCEs, or in other words, highly compensated employees, we can dive into that. Workers earning above a certain annual threshold, which is $107,432 federally, can qualify as exempt with a simplified duties test. But duties still matter. And then to dive a little bit into safe harbor policy requirement. So just a few points on that. Employers can maintain, including unauthorized overtime if permitted to work. Misclassifying employees as exempt when they do not qualify can lead to back pay, penalties, as well as legal claims. Exemption status if they have a clear written quote-unquote safe harbor policy allowing employees to report improper deductions. So that's just a few things to know about exempt versus non-exempt employees. And we're going to go over to safety, and we're going to dive into IIPP, or Written Injury and Illness Prevention Program. And just some points we have under that is going to be every California employer must establish, implement, and maintain a written IIPP under Title VIII. The program must include methods for hazard identification, correction, employee training, as well as communication for that. So they're just all kind of training videos and things of that nature that they would want to have in there. And then just a broader state plan coverage and stricter standards. Some points that I have under that is going to be Cal/OSHA, which is just a safety program that a lot of California companies, pretty much all of them, use and we operate under. So it operates under a state plan approved by the Occupational Safety and Health Administration, which is OSHA, and it can adopt standards more stringent than federal OSHA. For example, Cal/OSHA permissible exposure limits, which is a PELs for hazardous substances, may be lower than the federal limits to materials that may be lower. Just to go a little bit more into safety, how to maintain a safe workplace, keep walkways, aisles, and exits clear of clutter to prevent trips and falls as required by OSHA's housekeeping standards. And just in the parentheses are going to be all the citations for where in the OSHA handbook is going to be found. Ergonomic practices: adjust workstations to fit your body, monitor at eye level, feet flat on the floor, and wrists straight when typing to prevent musculoskeletal disorders. This is just kind of in the OSHA handbook, more towards a white collar job instead of something like either minimum wage or blue collar. Electrical safety, this is a big one. Ensure electrical cords are in good condition. Do not run under carpets and use grounded outlets to comply with OSHA's electrical standards. Fire safety compliance: know the locations of fire extinguishers and alarms and keep fire exits unobstructed as required under OSHA's means of egress standard. And then finally, reporting hazards: report any unsafe conditions, equipment malfunctions, or even potential hazards immediately. OSHA protects workers who raise safety concerns from retaliation.
The federal discrimination law started in 1964 with the Civil Rights Act. Title VII of this act says companies cannot discriminate against people based on the classes of race, color, religion, national origin, and sex. Sex originally meant you were male or female, but later came to include gender identity, pregnancy, and sexual orientation. In 1967, age became another protected class with the Age Discrimination in Employment Act, which protects people over 40 against discrimination. In 1990, with the American Disabilities Act, disability became another protected class. And finally, in 2008, the Genetic Information Non-Discrimination Act made it illegal to discriminate based on genetic information. This includes family medical history and genetic markers. The California state laws are based on protected classes as well. The Fair Employment and Housing Act covers all the protected classes in the federal laws, but goes further to include marital status, medical conditions, military or veteran status, perceived characteristics, such as disability or sexual orientation, reproductive health decision-making, and victims of domestic violence, stalking, or sexual assault. Note, there are two types of discrimination, and both are against the law. The first is unfair treatment as an employee. Some examples of this include hiring, firing, job assignments, training, pay, and promotions. The other type of discrimination is a hostile work environment. In this case, the problem is general bullying, offensive behavior, intimidation, threats, offensive jokes, or derogatory comments. The important thing to remember about both types of discrimination is that they only apply to the protected classes. This is important because if you are getting bullied but are not in a protected class, then you don't have a legal case. If you feel you are being discriminated against, the first thing you should do is talk to the person, letting them know it's a problem. This may be enough to stop the behavior. If it isn't, then you should report the behavior to your direct manager. If you're not satisfied with how the manager handles the situation, or the behavior continues, then you should report the situation to the Equal Employment Opportunity Commission. Remember, however, that the commission can only act if the behavior is based on a protected characteristic.
Benefits. This slide is going to go over Family and Medical Leave Act, vacation, and paid time off. So the Family and Medical Leave Act is a federal act, and the California Federal Rights Act is a state act. Both are pretty similar, as they both provide up to 12 weeks of unpaid job-protected leave for family and medical reasons. And they do differ a little bit, as the California Federal Rights Act applies to employers with 5 or more employees, while the Family and Medical Leave Act only applies to employers with 50 or more employees. Vacation is not a requirement. However, if companies offer it, there are strict regulations to it. For example, if offered vacation is not used, companies must pay out unused vacation on final pay upon employee termination. And then California also requires employers to provide 40 hours or 5 days of paid sick leave. Paid sick leave. The second slide is going to go over retirement and health insurance. The Affordable Care Act, under the Affordable Care Act, employers with 50 or more employees are required to provide health insurance that meets minimum essential coverage standard. Health insurance is required by federal law, but California does not mandate it. Every employer with at least one W-2 employee is required to provide a retirement benefit plan as part of the CalSavers mandate. And the CalSavers mandate started in 2020, where businesses with 100 or more employees had a deadline of September 30th, 2020 to apply it. And for employers with 1 to 4 employees, the deadline comes in at December 31st, 2025.
Privacy in the workplace is one of the most important parts of employment law that every salaried employee needs to understand. First, employees have limited privacy at work. Employers are legally allowed to monitor your company email, your internet use, and devices owned by that company. It's not personal, it's just preventative. The goal is to protect company property, maintain productivity, and prevent data breaches. So a key rule is that if it's the company's device or network, it is allowed and can be monitored. Employees should always assume work systems are being tracked, not to necessarily punish you, but just to protect the business and everyone working in it. Next, workplace surveillance also has boundaries. Cameras can be used in public areas like hallways, retail floors, or entrances, but obviously are never allowed in private spaces such as bathrooms or locker rooms and etc. Recording in those areas crosses a legal and ethical line. When we zoom out to the federal level, laws like the Privacy Act of 1974 helped establish the original rules for how personal information should be handled, but it only applies to federal agencies, not private companies. California then took it a step further with the California Privacy Rights Act, or the CPRA. This protects employees directly in the workplace, especially here in California. The law gives major rights, including, first, the right to know what personal information is being collected and how it's used, the right to access that data and request a copy, the right to correct or delete inaccurate information under certain conditions, and the right to opt out of having data sold or shared, and lastly, the right to limit sensitive information like health and financial records. These rights ensure transparency and accountability, so employees aren't left guessing about how their information is handled. Lastly, employers are also allowed to run background checks before hiring. This may include criminal history, employment verification, or even education records. But even here, privacy is still regulated. Employers can't access medical or genetic information unless it's directly job-related and a true business necessity. So overall, workplace privacy is really about balance. Employers have the right to monitor business systems, while employees have the right to personal protection. Understanding these boundaries helps salaried employees step into the workforce informed, confident, and prepared.